send that live now then if everyone's okay.
Hello, good afternoon, everyone, and thank you very much from all of us at the Law Society of England and Wales for joining us today for our Registered European Lawyers webinar. I apologize for the delay. We had a few technical issues, which we hopefully managed to fix now, so hopefully you can all see me. My name is Marco Cillario, and I am an international policy advisor responsible for Europe at the Law Society. I will be chairing the panel debate today alongside my colleague Michael Padua, whom you will be seeing on screen later today. We are here to discuss the impact that the end of the Brexit transition period will have on European lawyers operating in England and Wales. As you're aware, the UK has left the European Union. During the Brexit transition period, the UK is still a member of the single market and the customs union, but the transition period is scheduled to end at the end of December 2020. This will mean changes for European lawyers in England and Wales, and we are here to go into the details of these changes, answer your questions, address your concerns, and highlight the support that Law Society can offer. Now, in normal circumstances, we will be very happy to welcome you in our Chancellor Lane building for our annual Ariel summer reception. This year, unfortunately, due to COVID-related measures, this is not possible, and we're holding this event online. But we're very pleased to see that so many of you have registered to attend this event. We had more than 300 people registered to attend, so it's great that we can reach out to such a wide audience through this platform. I'm just going to briefly go through the program today. In a few minutes, you will be hearing from our Vice President and soon to be President, David Green, who will be giving us a welcoming speech and give you more details on why we're here today. And we will then kick off the panel debate. We have quite a panel here for you today. We have representatives from the Law Society, from the Solicitors Regulation Authority, and from the Ministry of Justice. The panel debate itself will be divided into two parts. In the first one, I will be asking the panel a few questions to kick off the debate and to go into a little bit more details as to what regulatory changes will affect European lawyers in England and Wales as of next year. In the second part, which will be chaired by my colleague Michael, and will start at about 3, probably 3:15 now, we will be answering questions submitted by you in the audience. You can submit your questions using the live chat that you should see on the right-hand side of your screen. We may not be able to answer all of your questions during the event, but we will follow up in writing with those questions that we were not able to address during the event. Before I hand it over to David, I also want to say thank you to Eleanor Farrow, who is the Law Society International Policy Assistant. She did a great work organizing this event. You will not be seeing her on screen today, but she will be working behind the scenes to make sure that everything runs smoothly. And also thank you to our events and IT teams for making this possible. I'm now going to hand it over to David Green, our Vice President, who I think is on the phone with us. David, thank you very much for joining us today, and over to you.
No, thank you very much, Marco, and I'm sorry I couldn't join in person, or at least in video. Technical difficulties, and as we've heard, we had some technical difficulties just at the last minute. So thank you very much for your patience. That there are 300, I think, probably reflects the degree of uncertainty amongst registered European lawyers and our colleagues about what is going to happen next year once the transition period ends. And hopefully we can today give you some answers to that and reassure you about the place or the way the UK is looking at it at the moment, which I think is actually quite certainty, does have certainty about it. And you've got a great panel today to answer your questions, that full range of regulator, Ministry of Justice and otherwise, and us, the Law Society. And I think that hopefully we can give you some answers today. So I am the Vice President of the Law Society. and I'm due to become president in about 4 weeks. And I should think that my presidency will be marked by being pretty virtual, so I'll be missing the mute button and other technical problems as the time progresses. So I'm sure I'll get lots of experience in that respect. England and Wales is a global legal centre, and indeed the other day we relaunched our global legal centre project, emphasising the place of England and Wales in the world in terms of a global legal centre. Flexibility of common law, reliable and independent courts and judges, and knowledge and experience all will really serve to make England and Wales a key international legal hub, and that's not really going to change with the end of the transition period. I think we will remain a key international legal hub. And one of the issues that comes up about that we've really highlighted over the past few months is the ability of the courts to respond to COVID-19 and all the circumstances in dealing with things remotely, and particularly the High Court, the Commercial Court, has done a really fantastic job of keeping on top of its listing and its trials. And I can give you 2 examples of the why we will remain an international legal hub. First is dealing with crypto assets. We have already had cases in relation to crypto assets, and we've already established at common law some principles relating to crypto assets. So very much highlights the flexibility of the common law and its ability to move along with events and modernization, for instance, of transactions in that way, so crypto assets and otherwise. The second is our ability to deal with matters remotely. I know that from my own practice, the arbitration world has also responded, whether that be LCIA or ICC or other hubs, institutions have responded well. And we've got just one other instance is we've got a couple of cases going on which show the power of the English courts, the abilities of the English courts. One was a recent one about its sort of mid-contract material adverse circumstances, and it's mid-contract. It had an English jurisdiction, and the Commercial Court has dealt with it very, very quickly because it's mid-contract and the contractors need an answer to it. An interesting case. Similarly, you'll all know about the case that's being taken in front of the Commercial Court at the moment on the terms of business interruption insurance. Again, a sort of collective case coming in front from a regulator to test on behalf of insurance, those insured, the terms of insurance policies, and a flexible and very certain way of dealing with a broad issue touching on many thousands of insureds under their policy. So we certainly remain a global legal centre, and we wish to keep that. And you are, I may say, part of that, because you are part of the legal community here. And the legal community here, because we have a very open jurisdiction, consists of firms from all over the world. Some will give you the statistics, but the number of firms from all over the world, and we remain a very open jurisdiction, employing many of Law Society's members in those firms, and that's very much the way that we want to go and maintain. Everybody benefits from it, and nobody loses. And I should say that when we have been talking to other bars around Europe, particularly, first of all, is they talk about reciprocation, and we say, well, that England and Wales is a very open jurisdiction and certainly provides that reciprocation. Secondly, is that those cities, particularly, that want to become global legal centres like London, also need to maintain this openness. And we've seen that, for instance, in Brussels. And Michael and I had a chat, and in fact, Marco had a chat with the Paris bar the other day, and similarly, they want to try and have an open jurisdiction. So that's very much the way we see it. So regardless of the outcome of this process, the end of the transition, European laws will always have a place in England and Wales, and will always be welcome by the homegrown legal community. We know that the end of the Brexit transition period will bring significant changes. The end of the REL regime will, with some changes to practicing rights and a different route to requalification available to registered European lawyers. However, I want it to be absolutely clear, the Law Society of England and Wales is committed to ensuring we remain that open jurisdiction. And we know from conversations with regulators and with the government that there is no intention to put in place any significant barriers to EU lawyers wanting to work and requalify in England and Wales. So that European laws will still be able to establish practices and firms here, partner with local lawyers, practice their home country law, international law, EU law, and England and Wales law outside of the reserved activities. And I think someone is going to cover those reserved activities. Although no longer able to requalify as solicitors through the EU Lawyers Directive, they'll still be able to use the Qualified Lawyers Transfer Scheme. And from autumn 2021, as you know, there are going to be changes, the new solicitors qualifying exam to gain greater access to the UK market. And we use the acronym of SQE. But that's from autumn 2021. And I know we have someone on the panel from the SRAs to discuss that issue. So it doesn't matter what form of future relationship we have with the European Union, whether when we have a no deal or there is a deal, seems very much up in the air, but that actually won't make any difference in terms of qualifying here and practicing here. Our work, the Law Society's work, has not been limited to representations to government and regulators. We've also got practical advice and guidance to support both members in the EU and our European colleagues in the UK. That's been spearheaded by our international Brussels team and Michael, who's on the panel today, and he will address any questions that you have in that respect. Marco and Michael Padua will be co-chairing the debate today, and they'll be happy to assist you in the future with any questions that you have. All our guidance and events to prepare members, including European lawyers operating in the UK, for the end of the transition period can be found on our dedicated webpage, and I'm sure that will be shared with you during the course of this webinar. Also, upcoming events on immigration, data protection, family law, and civil judicial cooperation. I know that for many of you, we'll be asking about Lugano and what's going to happen in that respect. So we're here today to discuss really the pressing questions, and as I say, try and give you some certainty about the future, where we can see that our daily headlines are that it's very uncertain what our relationship with the European Union will be post-transition. So now I'm going to hand over to Marco, who's going to begin the panel proper.
Thank you, David. Thank you very much. And certainly we are here to provide clarity to European lawyers operating in England and Wales and also to send home the message that we remain an open jurisdiction to international lawyers, including European lawyers. So I'm now very pleased to introduce you to our panelists. You have seen them on the slide on screen in the previous few minutes. We have Elaine Williams, who is Senior Legal Advisor at the SRA, Amanda Fox, Policy Associate, also at the SRA, Rebecca Woodward, who is Head of EU FTA Reservations, MRPQ and Market Access Africa at the Ministry of Justice, David Green, whom you've just heard from, and last but not least, Michael Logan, our Head of International at the Law Society. Let's now start our panel debate. I would ask panelists to stick to a maximum of 5 minutes for their answers, especially since we are quite a few minutes behind schedule. This will give us the chance to address more of the questions from the audience. Michael, if you don't mind, I will start by asking you to give us an overview of the implications of the end of the Brexit transition period for those who are currently registered as RELs in England and Wales. Michael, on to you.
Well, thank you, Marco, and delighted to have so many of you on our, with our webinar this afternoon. I think what I will cover, I'll try to be very brief because a lot of ground has been covered already. The UK has left the EU. The transition period is ending at the end of December, so we are less than 4 months away. And by leaving the internal market, what that means is like the EU directives are no longer applying to the UK. And by EU directives, we mean that the two lawyers directive, the Lawyer Services Directive on temporary practice, and the Lawyers Establishment Directive, which essentially structured the REL regime in England and Wales. The MRPQ Directive, the Mutual Recognition of Professional Qualification Directive, no longer applies. That's true, but we will talk about the QLTS, soon to be the SQE, on how to take a requalification exam to become a solicitor later during the panel discussion. So again, what that means is the end of the REL regime. That is true for lawyers from the EU, lawyers from the EEA, the European Economic Area, Norway, Iceland and Liechtenstein. However, that is not quite true for Swiss lawyers. The reason being that Switzerland negotiated a different transitional agreement with the UK, so the timeline are different. And Rebecca from the Ministry of Justice, I think, will say a bit more about that. I want to reassure people in the same way that David Green or Vice President did. We are an open jurisdiction for foreign lawyers, and we will remain so. What changes is the legal basis for your establishment. So the EU directives no longer apply. You will have the right to establish in England and Wales, to practice in England and Wales, but the relationship with the SRA, if any is required, will be different, and we'll come into the details of that. And there will be some slight changes as to what you can practice, even though we remain very liberal in terms of host state law practice, but also some practice in relation to English and Welsh law as well. I'll leave it there, Marco, but very happy to come back at a later stage.
Thank you, Michael. Thank you very much. Now, Rebecca Woodward, I will now hand it over to you because I will be very keen to hear the MOJ perspective on the changes affecting RELs. Rebecca.
Thank you, Marco. First of all, I'd just like to thank the Law Society for arranging this event and for inviting the Ministry of Justice to take part. I was just going to briefly cover the legislative changes that underpin the new arrangements that Michael was talking about. So in July, we laid a statutory instrument before Parliament. That's the Services of Lawyers and Lawyers Practice Revocation EU Exit Regulations 2020. This is intended, subject to parliamentary approval, to come into force at the end of the transition period, so the end of December. and it will come into force regardless of the outcome of negotiations. The SI will replace the existing regulations that passed through Parliament on legal services for Brexit in 2019, essentially to reflect the fact that we secured a withdrawal agreement and the transition period that went along with that withdrawal agreement. The new SI, as the previous did, will revoke the legislation that implements the Lawyers' Services Directive and the Lawyers' Establishment Directive in England, Wales and Northern Ireland, although it does save certain aspects of that legislation to reflect provisions in the withdrawal agreement, the EEA-EFTA separation agreement and the UK-Swiss Citizens' Rights Agreement. So for the withdrawal agreement and the EEA-EFTA agreement, it essentially makes provision to ensure that EU lawyers who are applying to join the solicitor profession, for example, under the terms of the Lawyers Establishment Directive, where it's essentially sort of based on 3 years experience, as long as they have their application in before the end of the transition period, that application will still be considered under those terms. As Mikhail mentioned, for Switzerland, for Swiss lawyers, apologies, the arrangements are different because of the terms agreed in the UK-Swiss Citizens' Rights Agreement. So Swiss RELs can retain that status as long as they remain registered. So there can't be a break in that registration following the end of the transition period. There is also an extended period of 4 years from the end of the transition period for Swiss lawyers to register as registered European lawyers. Along with that registration as a registered European lawyer, Swiss lawyers will also retain for 4 years the route under the Lawyers Establishment Directive, again the 3 years experience route, to joining a UK profession. Finally, I think it might just be useful for me to flag in considering for EU lawyers to consider the approaching end of the transition period would be their immigration status. And of course, there is the EU settlement scheme. So EU lawyers settled in the UK need to apply for that, for the EU settlement scheme, the deadline for which is the end of June 2021. EU citizens arriving in the UK after the end of the transition period will fall under the UK's new immigration system. And I think it's also just to flag that obviously that you have your an event based on immigration, I think on Monday the 14th of September, which will be able to cover off those arrangements in more detail and give a bit more information on those.
Thank you, Rebecca. Thank you very much. Yeah, you helpfully reminded of the event we're going to have next week on Monday, the 14th of September, which will cover the UK new immigration regime. So obviously this is, I assume, a very relevant topic for our audience today. So we will be sharing a link to register for this event. And please register to hear more about the new immigration system. It will be at 10 a.m. on Monday the 14th. Now, Elaine Williams from the SRA, I would like to ask you to give us a little bit more details on the changes for European lawyers in England and Wales in terms of practicing rights. So put very simply, what is it that RELs can currently do in terms of practicing rights that will change for them after the end of the transition period, assuming they do not requalify as solicitors?
Hi, and I'd like to repeat the thanks that Rebecca's given for the TLS for setting this up and for inviting us to come along and join in with you. The end of the REL regime will affect the services that you're able to offer and also the capacity in which you can deliver those services and to some extent be able to be involved in UK law firms. The good news is that you'll still be able to deliver a fairly wide range of the services that you currently offer. So, for example, you'll be able to advise on your home country law, you'll be able to advise on community law and international law, and you will still also be able to advise on English and Welsh law, provided that you do not carry out any reserved legal activities. So just by way of example, you would be able to advise on corporate restructuring and company law. So the major change in the services that you will be able to provide going forward is that you will not be able to carry on reserved legal activities in your own right. You will still be able to provide some reserved activities if you're supervised by an authorised person such as a solicitor. It is the Legal Services Act that sets out what activities are reserved, and the definitions, the detail of the definitions can be found in Schedule 2 to that Act. The main activities to note which are reserved are the conduct of litigation, the exercise of rights of audience, reserved instrument activities, which does include preparing some court documents, and also probate activities. As I said, the Act contains quite detailed definitions of what these are, and also gives details of which of the reserved activities can be carried out under supervision, and that you can find that in Schedule 3 to the Act under the definitions of exempt persons. Another change is that you will no longer be required to register with us simply because you are permanently established in England and Wales, as you're currently required to do. So in the future, your relationship with us will depend upon what services you want to offer and through what type of entity. There will be a range of options open to you, and I think we'll cover those a bit more detail during the course of the webinar. As I mentioned, there will be an impact on how you can be involved in law firms that are authorised. So if you wanted to be a lawyer manager or a lawyer owner, then you'll have to become a registered foreign lawyer or become a solicitor. But you can be an owner or manager of some bodies, those which are licensed bodies, as a non-lawyer. You can't do this in a recognised body. The other change is that you won't be able to be a recognised sole practitioner or one of our new freelancers. I think that pretty much sums up the major changes in what you'll be able to do as from the 1st of January.
Thank you very much, Elaine. That's very helpful. Amanda Fox, also from the SRA. I would like to learn from you what Ariels can do to prepare for these changes between now and the end of the year. I guess a lot of our audience will be wondering what is it that they can do now that they might not be able to do after the end of the transition period? What is it that they should do to prepare for the changes?
Okay, thank you. Just would like to add my thanks to you as well for inviting us. In terms of what RELs and firms need to do between now and the end of the year, the good news is that they don't actually need to do that much. So we will ask people to renew as normal in October this year, to renew as RELs, and then they will remain as RELs until the end of the transition period. And then I think, as other people have alluded to, they will move over to RFL. So what we will do as the SRA is we will passport all RELs to RFL at the end of the transition period, so from the 1st of January 2021. And RELs don't actually need to do anything to affect that, and we will aim to make that a really seamless process. There will be obviously a small number who don't want to passport to RFL status, so we would ask those individuals who would actually want to practice under their home title going forward to actually contact our admissions team direct. There's a very simple form online to do that. We think the cohort will be fairly small. The take up so far has been pretty low, but that is an option that is open to current RELs. So that's really it in the terms of process. I think as Rebecca mentioned in her answer, we will be accepting applications under the Establishment Directive right up to and including the end of the transition period. So, in point of fact, you could put in an application at 11 p.m. on the 31st of December. And we will commit to processing those applications on into the new year. Having said that, we would probably encourage people who are wanting to go down the 3-year establishment route to actually get applications in a little bit earlier than that, if they possibly can. The applications do take a bit of time to actually process. I think about 3 to 4 months to actually process. So would really encourage those RELs who believe they meet the eligibility requirements to get their applications in sooner rather than later. And the only other thing that I think is probably worth flagging up at this stage as well is that we are very mindful of the disruption that COVID has caused to people. There's been a lot of home working. Some people may have been on furlough. So we will take into account everybody's individual circumstances when we're actually processing their application. We have decided not to put any sort of blanket exemptions on anything like that, because every individual's circumstances will be entirely unique. But I'd just like to reassure people that we are committed to being as flexible as possible as we can be.
Thank you very much, Amanda, and I'm sure our audience will be reassured to hear that. I've got another question, which is about going into a little bit more details into the RFL registration requirement. We're talking about registered foreign lawyers. Obviously, this regime, the registered foreign lawyers regime, remains in place and will possibly cover those who are currently registered as RELs. So I'll bring in Mikael to, I guess, give us a little bit more details on the RFL regime and when registration is needed. But obviously, if Elaine, Amanda, or indeed Rebecca or David want to also chip in on this, please feel free to. But Mikael, if you could just give us an overview of the registration requirements in terms of RFLs, and then perhaps Elaine and Amanda can, if they want to, give us a little bit more details on that.
Well, thank you, Marco. And indeed, I mean, I'm speaking under the control of our colleagues from the SRA, and both Elaine and Amanda have actually covered already quite a lot of what I would like to say. But again, just to be clear, the REL regime is coming to an end. Your relationship with the SRA will be different. Thankfully, in terms of change of process, the SRA is, as Amanda said, working really hard to make it as flawless as possible, and you will be transferred to the RFL regime. The RFL regime is not based on establishments. It's based on whether you are an owner or a manager of an authorized body. Authorized body is obviously is a technical term to say a firm, a law firm, authorized by the SRA to undertake reserved legal activities. There are other ways to practice as a lawyer in England and Wales. You can practice through a licensed body, which is the term used for alternative business structures, where non-lawyers are also have the possibility to be owners and managers. You can also practice in an unregulated legal business. So just to give you maybe a couple of examples, if you are in a foreign law firms where all the lawyers, all the owners and principals are foreign lawyers, you do not need to register as a RFL with the SRA. Your regulatory relationship is on a different footing than obviously the REL regime. So it'll be for each of you to obviously to go back to the SRA. Again, if you're already registered, the transfer will be done automatically, but to go back to the SRA to see if you do not need to register. And obviously for European lawyers arriving in England and Wales for the first time, they will have to look at whether they need to register as RFL at all. I ought to mention another category of European lawyers, which is called exempt European lawyers. As the event is for registered European lawyers, I assume that all of you are established in England and Wales, but they are exempt European lawyers, which are actually owners or managers of SRA authorized body, which are based outside of England and Wales. They may be based in offices, branches of UK LLPs in Paris, in Germany, in Brussels, in Milan. Again, that regime will end, and they will need to become RFL. Likewise, the SRA will be in touch with exempt European lawyers before the end of the transition period to again to have that smooth transition to the new regime. Thank you.
Thank you very much, Michael. I don't know if Elaine and Amanda have anything to add to this. If not, I guess I'll move to the next topic, which is again looking ahead at 2021 and from 2021 onwards, assuming that the transition period ends at the end of December 2020, as it currently scheduled to. If European lawyers want to requalify as a solicitor from 2021 onwards, so they will no longer be able to use the EU directives to do so, but what are the options for them going forward? And Amanda Fox, I guess this is for you, but again, if anyone else wants to chip in, please feel free to.
Okay, yeah, thank you. So again, as colleagues have mentioned before, can attempt either the QLTS, the Qualified Lawyer Transfer Scheme, or the SQE. Should just point out that the SQE is due to come in during autumn 2021, but at the moment it's still with the Legal Services Board for approval, and we're expecting to have a decision from them this October. Just like to flag that our education and training team are working really hard at the moment to try and make the best arrangements for candidates during the transition between the two. So with the QLTS coming to the end, in order to get into the QLTS transition cohort, you must have passed the multiple choice test part of the exam before the 1st of September 2021. If you haven't passed it by then you'll have to take the SQE. So if you're in the transitional cohort, you'll then have a further year to attend the practical skills-based part of the exam, which is called the QLTS OSCE. But what we would say is that anybody who's got any doubts or worries about whether they'll be able to get through the QLTS before the SQE comes in, the advice, really strong advice from our education and training team, is to concentrate on attempting the SQE and basically to begin to work towards that from now. Thank you.
Thank you, Amanda. That's very helpful to know. I guess coming to an end of this first part of the panel debate, and before we move on to the questions from the audience, David, if you're still with us on the phone, you mentioned, hello. You mentioned the point about England and Wales remaining an open jurisdiction for foreign lawyers after Brexit, no matter what the outcome of the negotiations is. I guess other panelists also touched on this point. I'm wondering if you want to say anything else about what this means for European lawyers specifically.
Not particularly. I mean, I think that the other panelists have obviously covered the technical issues. In a broad sense, I have covered the fact that we will remain an open jurisdiction. And that's very much part of the plan as going forward. So there's going to be no, from our point of view, is we want to make your ability to practice in England and Wales as easy as possible. I think you've covered some technical points about reserved activities and what registered foreign lawyers or RFLs can and cannot do. But it's those reserved activities which are reserved for solicitors. So that's the difference there. So I think that we might better go to questions that people have that they want to that are troubling them in what are clearly uncertain times, and hopefully we can provide some certainty. As I say, the Law Society is here to help. Have a look at the website. We very much want to assist those working in England and Wales and provide some certainty for you as we come to the end of the transition period.
Indeed, thank you, David, and definitely let me reiterate as a member of the Europe team of the Law Society that we are here to help with any queries and concerns you may have. Good, so we are now on time. Actually, it's 3 p.m. Good time to move to the second part of this panel debate, which is the part where we address the questions that we have been getting from the audience. I've seen that there are quite a lot of questions we've been getting. We have selected a few. The others will still be addressed in writing after the event, so all queries will aim at getting a reply to. I'm gonna hand it over to my colleague Michael Padua to chair this part of the panel. Michael is also an international policy advisor for Europe here at the Law Society. He's a member of the Europe team with me. So Michael, on to you.
Thank you, Marco. Thank you to everybody who's joined us for this event. I've been monitoring the questions as they've been coming in, selecting some of the maybe more interesting ones and packaging some of them together. There's a lot of people that are in similar situations. So the first one that I'm going to start with is for the panelists from the SRA, Elaine and Amanda. Basically, there's quite a few people that are wondering what happens to RELs who will fall just short of the 3 years. It may be by a few months, it may be by a few weeks, or in one case, even by a single working day. Also, people are wondering if you're counting that experience starting from when they register as an REL, or whether previous experience counts as well. And they're also wondering about gaps, for example, for maternity leave. Maybe you can address that.
Okay, so unfortunately, there has to be a cut-off date. The REL regime is essentially a statutory regime. It's completely founded in legislation. The UK legislation is derived from the directive. So the MOJ, as you've heard, have just laid before Parliament a new SI, which will bring the regime to an end at the end of December. So the cut-off date was extended beyond exit day until the 11 p.m. on the 31st of December this year. And basically, in order to be eligible to apply using the integration route, that's the working 3 years in the UK, you have to have been registered for 3 years. So as tough as it seems, so for those of you that are just going to fall short, that's just where the cut-off point has landed.
Can you address the issue of gaps, for example, for maternity leave or other life events like that?
So the regulations require that the consecutive, effective and regular pursuit over a period of 3 years. I think in terms of people who've got gaps, it'll very much depend upon, you know, what those are, how long those are, or why they are. In relation to maternity leave, I think that's a very specialised situation, and I'm not quite sure of the answer to that. But I mean, I think that's one way we would need to know your specific circumstances and how long the gaps were in your effective and regular pursuit. I'm not sure if I'm right, and again, we'd have to refer the question to our admissions team. But if you've let your registration lapse, then that might be a problem. But if you've continued with your registration, but you have gaps in your effective and regular pursuit, but those relate to everyday life, or they're very short for, you know, you might have had an extended holiday, then I know that those will not exclude you. But it literally is very much in this area a case-by-case analysis that we conduct. So I think the only way forward is for you to sort of perhaps let us have your details so we can you know, check with our specific team which deals with these applications all the time.
Yeah, I just say, yeah, completely agree with Elaine. I was just going to come in on Elaine's last point, which is that, you know, it's case by case specific, and we look at the individual circumstances. So we really would encourage people who are affected to, you know, to get in touch with us or with our admissions team.
Great, thank you very much. Here's one I think for Rebecca at the MOJ, and Mikhail might want to chip in as well. They're asking whether there is a future for potential reciprocal agreements with European bars that might grant privileges on a country-by-country basis, for example.
I think we referred to recognition of qualifications earlier in the discussion. Obviously, they're currently that area is currently subject to negotiation, but we are aiming to ensure that as we go forward in future, that regulators and potentially in conjunction with professional bodies can make agreements with their counterparts in the EU going forward. So that might be a possibility. In terms of how quickly those agreements may be put in place is an outstanding question, because through experience these things can take time.
Thank you. Just to follow up on that, I mean, indeed, Rebecca is right. There are negotiations taking place at the moment, and as we have seen with the Swiss example, you know, we may get a different agreement with EFTA countries, so Norway, Iceland, Liechtenstein, and Switzerland, than with the EU. And obviously we will see what the outcome of the negotiation with the EU would be, even though I think it's unlikely that they would deal with legal services in an ambitious fashion. As part of this negotiation, there is often in FTAs, free trade agreements, a chapter on MRAs, mutual recognition agreement, whether they cover recognition of professional qualifications or not. Obviously, the SRA already has a recognition regime which is open to all European professions. It's the QLTS, the SQE, and it's compliant with WTO norms, so WTO standards, so World Trade Organization standards. So I think there is already a requalification path for European lawyers, but MRS can deal with other matters. So we'll have to wait for the outcome of these negotiations to see whether anything can be explored under these these type of agreements.
Thank you, Mikkel. I think this here's another one that I think will go to you. And we're being asked about what's the situation on the opposite end, that is for English solicitors that are practicing in EEA jurisdictions. What are the rules for them, and what are we doing to help them?
Okay, I mean that's obviously a great question. It has been the focus of a lot of our work, the international department, the Europe team. So Michael and Marco in the past in the past few years. When the UK leaves the single market, essentially we're moving away from one single framework with rights and obligation, the lawyers' directives, the MRPQ directives, and we will move subject to the agreement with the EU, but we will move to 31 different regulatory regimes, and each of them being very different in terms of what they allow foreign lawyers, because our members will become third country lawyers, so what they allow to practice or to do in the different European countries. So some jurisdictions in Europe are very open, very liberal, similar in some ways to England and Wales. So we expect very little, very few issues for members, individual solicitors, and UK law firms. While some jurisdictions are a lot more complex and challenging, so they often have not considered opening up their legal services market to non-EU legal services providers. So what we are doing, obviously, our first focus is on information, so trying to find out what is the regulatory regime for third country lawyers in the 31 jurisdiction of the EU and EFTA, informing our members. Obviously, we spend quite a lot of time, and I say we, it's Marco and Michael spend quite a lot of time talking to individual solicitors and UK law firms about their individual situations and their Brexit contingency plans and what they need to do. Do they need to requalify to be able to remain in jurisdiction? Will they be able to continue under their home title? And for the structure, do they need to requalify? What are to restructure? Sorry, what are the parameters to take into account for continuous practice? I'll stop there because we could literally spend hours on that issue. But just to say that if you have any question, either as an individual or as a firms, please feel free to contact the Europe team, and we can provide you with specific guidance for whichever jurisdiction you're interested in.
And I might add is that there was at one time a rush to requalify in Ireland, in the Republic of Ireland. That got a little bit of a pushback from the regulator in Ireland, but it's still a course that some people wish to take. It has some privilege advantages which are important in certain practices, and again the Law Society can guide you as to where we now stand in relation to the Republic of Ireland and requalifying there.
Thank you, David. That's a very good point.
I'm having some questions regarding impact of COVID, both in terms of potential gaps in employment here, as well as potential difficulties in obtaining documentation for the RFL application process or other documentation required by the SRA that because of COVID, they're having trouble obtaining those documents or the delays are longer than usual. Can you talk a little bit about how you're dealing with those kinds of COVID-related delays?
Yeah, and obviously, we're very alive to that. It's an issue really, across all of our work. When we're trying to get information from firms, whether it's for for our enforcement work or whether it's for applications and admissions. So, I think I would just reiterate my earlier point to say that we're being very flexible and pragmatic. But in terms of making applications, I think the important message really. In terms of the documentation is to make the application, and then we can start to consider the case on a case-by-case basis, and likewise as well with gaps in employment or furlough. We want to be pragmatic and flexible and work with people.
Thanks. Here's somebody asking about the requirements for admission under Article 10.1 and Article 10.3 of the directive, and what the difference is between the two.
Okay, so under 10.1, essentially you've got to be registered as a REL for 3 years, and you have to practice in England and Wales in the law of England and Wales or community law for 3 years. 10.3 is slightly different because although it's still the requirement that you have to be registered as a REL for 3 years, and you've got to pursue professional activities in England and Wales for 3 years. You don't necessarily have to have done that in English and Welsh law and community law. So you might have done that, say, for 2.5 years, and have done other types of work for 6 months. What you have to do is to supplement, to show that you've supplemented your sort of 2.5 years experience by, for example, training, other professional activities. So that's essentially the difference, that you can show us in some way that what element of time is missing is supplemented in a different way.
Thanks. There's probably going to be a lot of questions directed mostly to the SRA. I have a question about in-house lawyers and how all of this applies to them.
I think it depends on what services you're offering. So if you're just offering non-reserved services to your employer, then I think you're going to have a choice about how you practice and whether you want to become an RFL or not. I'm not quite sure of the answer. I think that it would depend on what you're doing and how you're practicing.
Okay.
Michael, if I can maybe
sure.
add to that, because not all in-house lawyers were able to benefit from the REL regime. They obviously, to register as an REL, you need a certificate of attestation from your home bar, and as we know, not all European bars authorize for in-house practice. Article 8 of the Lawyers Establishment Directive did provide a route for REL registration with the SRA, but we know from having taken some individual cases that not all European bars were keen to enable their members to provide activities in-house. So for those who were not able to register with the SRA, and for those who will obviously move out of the REL regime with the end of the transition period, they can obviously continue practicing in England and Wales as European lawyers, as foreign lawyers, with their respective companies or organization.
Thanks. Also, there's a number of inquiries from sole practitioners, and I know we covered this, but maybe we can just go over it again in terms of what happens to sole practitioners.
So unfortunately, you won't be able to have a recognised sole practice after 31st of December. So I think you will need to look at what activities your practice conducts. We have been talking at the SRA about communications with people who are registered with us as recognised sole practitioners to let them know what will happen, what they need to do. I mean, essentially, if you do carry out reserved legal activities, then you won't be able to do that in your own right after the end of December. So you would need to restructure your practice. If you don't carry out any reserved activities, it is possible that you could continue to practice your firm in an unregulated way. But I think if you would like some, further information, depending on the particular nature of your practice, again, I think that's something to come to us directly with. But there are some comms out about sole practitioners, and we will be intending to issue more.
Thank you. I have a question on the QLTS. If someone passes the QLTS and is admitted to the role of solicitors in England and Wales, do they need to remain also admitted to the role in their home country, or is that no longer necessary?
So I don't know if Elaine's got sort of any insight on this, as I'm not quite as close to the education and training, but if not, that might be a question that we need to take away, unless Elaine, you know the answer to it.
My gut reaction is that once you are a solicitor, you're a solicitor, and you won't then need to continue to be registered in your home state. The need to be registered in your home state while you are at REL comes from the Establishment Directive. So yeah, I think you could just be a solicitor if that's what you wanted to do.
I would agree with that. It's Michael Laurence here. Obviously, it may be in your benefit to continue with 2 qualifications, maybe from a career point of view, but there is no requirement to keep registered with you home bar or your first qualification once you have requalified as solicitors.
Yeah. So I think it's right, is that once you're a solicitor, then you have entirely requalified, and your original qualification can fall away. And of course, we've been talking about reserved activities quite a lot, and they're quite an important element of professional practice here, which solicitors can practice, but non-solicitors can't. And it's worth familiarising yourself with those reserved activities. I think they've been covered already, so I won't repeat them, but it is worth looking at those reserved activities. They're core to the way in which our regulation occurs.
Marco, how are we doing for time? Should we move on to the conclusion, or do we have time for another question?
We can have another question. It would be good to address more that are coming.
Sorry, let me just roll through the ones that are coming in as I'm speaking.
Sorry, I think if I can just say, I think there are a few questions that again concern registration as RFLs. There are questions as to whether in-house lawyer need to register as RFLs or in general who needs registration. We touched on that, but perhaps we could we just clarify the point on who needs to register as RFL. And I think Michael touched on this, but perhaps we could say in clearer terms when RFL registration is needed and when it is not needed. I don't know if Mikhail, you want to go back on the point, or Elaine or Amanda.
I mean, I'm happy to do so, but I'm very happy for further input from the SRA. So you're only required to register as an RFL if you're an owner or manager of an authorized body, so a law firm which is regulated by the SRA to undertake reserved legal activities. In layman's term, essentially, if you are a partner with Solicitors of England and Wales, if you're a director of a law firm, incorporated, or if you are a member of an LLP, these would be examples where you need to be registered as an RFL, whether you are established in England and Wales, or whether you are outside of England and Wales as well. So it's what we're saying about the, also the transfer of the exempt European lawyers who are established in Europe but outside of England and Wales into the RFL regime. Elaine, Amanda, I don't know if you want to add to that.
Yes, I think that pretty much sums it up. And the only exception to that is, as I think I just mentioned very briefly, you can be an owner or manager of particular types of bodies. So if it's a licensed body, and you do have another lawyer involved, then you wouldn't necessarily have to be an RFL. But if it's the other type of structures, so the very traditional law firm, what we call recognised bodies, then you would have to be an RFL to still be involved in that capacity. In relation to what we used to call exempt European lawyers, again, we have indicated that we will try to passport those people to RFL status unless there's an indication that they don't want that to happen. And the relevant law firms should be alive to that. Yeah, so that should be happening as well at the moment.
Thank you all.
What we will do, sorry, Marco, just to add to that, but there is very useful guidance, obviously, on the SRA website about RFL registration, including some points on the consequences of Brexit. So if we can send this link to all delegates, I think that would be helpful to answer all these questions.
Yeah, can I just add to that guidance covers quite a lot of the questions I've seen coming up, and it has a quite long section on the difference of the rights of RFLs and RELs, which might be quite useful to people. And it also has a dedicated section on EELs and what the problems are, as well as on the sole practitioner issue.
Thank you very much, Elaine, Mikhail. Yeah, just to say from me that we will follow up with one or more emails to the delegates today, where you'll get more information about contact details if you have further questions, links to some of the things we've mentioned during this event. So just look out for that email. I guess now it's time for us to draw to a close. So unless there's anything else from you, Michael, I would say we can hand it over to David for his closing remarks. And so thank you all very much for joining us today, and on to you, David.
Yes, unless Mikhail has anything to add. I hope what today shows is that we are here to assist. The MOJ, the SRA, the Law Society are here very much to assist you at what is clearly an uncertain time for people. And we are here with the message of keeping England and Wales an open jurisdiction. We have welcomed all our European colleagues, and we will continue to welcome our European colleagues. We may be leaving the European Union, but we are very much part of Europe. And of course, we've got this huge cross-border trade that will not, in some fashion, disappear for the future. It is, I think, unfortunate that the free trade agreement, if we have one, will be pretty limited now. I think that's clear. And the question is, will it include services, and will it drill down into legal services? They're open questions, but I think as time goes on, we can see that there will be severe limits on any free trade agreement that we come to. As far as the Law Society is concerned, is we maintain a relationship with all our fellow bars and regulators around Europe. And that means, as Mikhail was saying, is there's about 31 different regulators around Europe. He and I and others, we have a Brussels office, but also Marco and Michael are talking to other bars on a regular basis just to maintain the message that goes forward. Thank you very much to the panelists. Very kind. I'm sure that if you've got further questions, you're going to be given a link to the SRA site. There's much on our own website at the Law Society, and there will be material at the MOJ. So please have a look and come back to us if you've got questions. We've got to the Law Society, Mikhail and Marco and Michael that you've met, and they are here to assist you. Again, thank you very much to the panelists. Thank you, everyone. Thank you to the IT providers today. I'm sorry we had some little hiccups there, and I'm sure that my not being able to get on my phone is entirely my fault. But thank you very much indeed, and thank you, everyone. So enjoy the rest of your day.
Thank you. Thank you very much.
Sorry, it's Michael. I think we should just mention also that we have been recording, and we will make the recording of the session available to the participants. Thank you.